defending, mitigating, and avoiding the case you never thought you had. Hello, yet again. This is Forrest Owens. I'm an aviation lawyer, a private pilot, and an FAA licensed airframe and power plant mechanic. Finally, let's discuss the issue that matters most after the phone rings. The letter arrives, or the inspector asks for a conversation. How should an airman respond, and how good cases are prevented before they even exist? The first principle is to separate safety response from legal response. If there has been an operational event, and address safety immediately. Secure the aircraft, preserve the records, protect the data, and document what happened. But do not confuse that with volunteering a polished narrative before the facts are known. In these cases, the chronology is power. Save the flight track data, dispatch notes, screenshots, maintenance records, text messages, training records, and medical correspondence. If the later case turns into what an airman knew and when the airman knew it, contemporaneous records will matter far more than reconstructed memory. The second principle is to understand the difference between cooperation and self-inflicted damage. FAA inspectors begin with what looks like an informal discussion. Sometimes it's informal. Sometimes it is the front edge of an evidentiary file. You should be respectful and you should be professional, but also be careful, accurate, and deliberate. The third principle is to recognize when the case may still be steered towards correction rather than sanction. The FAA's compliance program, it does reward candor, responsibility, and meaningful correction action in the right kind of case. If the event was inadvertent, isolated, low risk, and honestly reported, early correction framing can matter. But there are hard limits. Compliance action is generally not the right answer where the FAA sees intentional conduct, reckless conduct, falsification, substance-related issues, or a true qualification problem. In those categories, the airman should assume the case may move into formal enforcement territory quickly. A related protective tool is the Aviation Safety Reporting Program under Section 91.25. The FAA generally may not use reports submitted to NASA under the ASRS for enforcement purposes, except in excluded categories such as accidents or criminal offenses. Advisory Circular 00-46F and NASA's published caveats also explain any waiver of sanction is limited. The event must be inadvertent, timely reported, and not otherwise disqualifying. This means that the ASRS is important, but it's not magic. It can be a shield in the right case. It's not a pardon for intentional misconduct, accidents, criminal conduct, or qualifications fraud. Another misunderstood point involves emergency orders. When the FAA believes safety requires immediate action, it can issue an emergency suspension or revocation. That accelerates everything. The NTSB's deadlines shorten, and the pressure on the certificate holder increases immediately. These are not cases to drift through casually. There's also a strategic lesson from falsification cases. In operational cases, sanctions may sometimes be mitigated. In intentional falsification cases, mitigation is much harder because the FAA and board treat dishonesty as evidence that the certificate holder cannot be trusted within a system built on trust. That is why the defense objective in those cases is often not sanction reduction. It is defeating the intent element itself if the facts support that defense. For Mechanics and instructors, the same logic applies. An enforcement case is not only about whether a flight was safe, it may be about whether an endorsement, return to service entry, or application statement was true. The record you create on the ground may carry more legal weight than the flight you performed in the air. A boardroom quality prevention strategy for airmen, therefore, has 5 parts. Know the privilege you're exercising. Know the currency and qualifications rule that apply. Answer every FAA form as if it will be litigated. Report when reporting is required. And never improve a fact after the event. This last point is one that I'd like you to remember. Many airmen survive the deviation. They do not survive the explanation. A final practical example makes this point stick. A pilot busts a clearance, files a prompt ASRS report, preserves the data, avoids speculation, obtains counsel before responding in writing. That pilot may still face scrutiny, but the event remains an operational case. By contrast, a pilot who backfills a logbook, changes a training entry, gives a confident but inaccurate statement may transform the same matter into a character case. Here's the memorable point. FAA enforcement becomes dangerous when a flying problem turns into a truth problem. In short, airman enforcement is misunderstood because many pilots focus on whether the flight felt safe, whether the FAA focuses on whether conduct was compliant, provable, and trustworthy. These are not always the same question. Here is the takeaway line. In an FAA case, the best defense usually begins long before the investigation, with disciplined flying, disciplined records, and a disciplined response. Thank you for your interest in this topic. This information is provided for informational purposes only, and it should not be construed as legal advice. Please direct questions, and they are certainly welcome, to admin@aviationlegalcounsel.com. We look forward to helping you navigate these issues with precision.